You are now listening to the Fighting Back Podcast, and here's your host, Jessica Travis. Welcome back to a brand new episode of the Fighting Back Podcast. My name is Patricio, a.k.a. Rocky, and I'm here with the one and only Jessica Travis. How you doing, Jessica?
Hey.
What are we doing today? What are we talking about?
Let's talk about stand your ground.
All right.
Come on, it'll be fun.
It will. We'll be good. We got this. So, Jessica, break it down for me. In simple terms, what is stand your ground and what does it mean here in the state of Florida?
So stand your ground is an immunity. So it means that you are immune from prosecution. You are allowed to meet force with force. So the statute says that you are justified in using deadly force if the force is necessary to prevent imminent death or great bodily harm. And we normally think of it as meeting force with force. So you can be immune from using deadly force. You can be immune from using non-deadly force. So long as the deadly force is justified if it's necessary to prevent death or imminent death or great bodily harm.
Okay. How does that differentiate from the traditional self-defense here in Florida?
Yeah, so self-defense is a defense. So what that means is that the state can prosecute you, and it's up to a jury to determine if you are acting in self-defense. With stand your ground, it's different because it's immunity, which means if you qualify, if your actions are justified under this statute, then the state attorney's office cannot prosecute you for your actions. So immunity versus self-defense is a really big distinction.
Yeah, because I'm going to say right now that it's kind of hard to decide what you're going to do when your life's on the line in a few seconds. Like, do I defend myself? Do I let it happen? Wow, okay. So that's a lot right there.
Right.
All right. So if someone invokes stand your ground, like what happens legally? Is this like an automatic immunity or does it have to be actually proven?
Yeah, so the procedural process for stand your ground, and if somebody is charged with a crime and they believe that they acted under the stand your ground statute and their actions are immune, they file a motion. Mm-hmm. It's a motion to dismiss, and that lays out the details of what happened in that particular case and why their actions were justified under the stand your ground statute. At that point, there is a hearing in front of the judge, where the state presents evidence and witnesses to show that their actions were not justified, that they're not immune from prosecution, and the defense can present evidence and witnesses to help the judge determine whether their actions were immune.
Because I was just about to ask, what role does a judge play versus the jury when stand your ground is raised in a case? Yeah,
so when we're talking about stand your ground and immunity, the jury's not even involved at all. It's the judge who's the finder of fact. So the judge is the one that has the hearing, listens to the facts, listens to the witnesses testify, and makes a determination as to whether the actions were justified and whether the individual is immune from prosecution. So it's a judge's decision, mm-hmm. and the judge is the finder of fact to make that decision. It doesn't even get to the jury.
Ooh, okay.
If a judge finds that the person is immune from prosecution, the case is dismissed. The judge dismisses the case, and the prosecution is over. Only if the judge finds that the actions do not qualify under the stand your ground statute and the person isn't immune from prosecution, then the case goes to a jury in which the defendant at that time mm-hmm. can argue to the jury self-defense and can argue to the jury that the person acted in self-defense, and the jury can determine whether the person acted in self-defense or not.
So if a judge determines that standing your ground, it qualifies as standing your ground, would the state be able to prosecute the defendant in a different manner, or it's like the defendant won at that point?
That's it. The case is dismissed. If the judge found that the defendant's actions qualified under stand your ground and that they were immune from prosecution, the case is dismissed and it's over. They can't be prosecuted anymore.
Now, can I throw you a hypothetical?
Sure.
See how this plays out. So let's say, for example, I'm in a parking lot and someone is threatening me. How would stand your ground potentially apply in that sense?
Yeah, so when we're talking about stand your ground, we're really talking about meeting force with force, right? So deadly force is justified if it's necessary to prevent imminent death or great bodily harm. right? So we're talking deadly force. It can only be used to prevent imminent death or great bodily harm.
So if someone comes at me with a knife, I can't just pull out my gun and shoot them.
Well, it depends.
Ooh, okay.
Right? Isn't that? So these stand your ground cases are really fact dependent, right? Because the first question that you have to ask is what kind of force is used, whether it's deadly force or non-deadly force. There's a lot of times a question about that, right? Is a gun, we know, is deadly force, but is a broken bottle, is that deadly force or is that non-deadly force?
Oh, okay.
Right? So the first question is what kind of force was even used? The second question then is where was there imminent death? Was there imminent great bodily harm? In which case deadly force can be used. Or was there only imminent harm or imminent danger or some type of non-deadly imminent harm or great bodily harm that's used?
Okay.
In which case only non-deadly force would be allowed and immune from prosecution, right? So when we're talking about meeting force with force, it's kind of like that saying of you don't bring
a knife to a gunfight.
Right. There really has to be a determination of what kind of force was used by the one individual and what kind of force was used by the other individual, and where is the imminent danger there?
Wow. I have so many more questions that I want to ask you that I'm probably have to ask you off camera.
Fair.
But I'm going to ask you another hypothetical that kind of leads into this. What about like if I was in my house and then there's a threat that comes in? Do I respond back? Am I standing my ground? Like how does that apply?
Yeah, so there used to be a common law doctrine of the castle doctrine. I don't know if you've heard of that before.
No, please.
But the castle doctrine essentially was an old common law thing that said your home is your castle, and therefore you can protect your home and you inside your home. So in common law, before stand your ground, if somebody came into your home or if somebody attacked you in your home, at that point, you were allowed to use deadly force against that person. Right? Because it was assumed if somebody was coming into your home, they were coming in your home and there was imminent death or great bodily harm that was about to happen.
Oh.
Right? That's your castle doctrine, and that's been around forever. With stand your ground now, you not only have that castle doctrine, but you don't have to be in your home anymore. You can stand your ground out on the street. You can stand your ground in any place, and it doesn't have to be in the home. It used to be the home was that special protection of, okay, I'm defending myself in my home. Now your stand your ground can be anywhere, and there's no duty to retreat. That's the other thing that's pretty important in most circumstances. Now, if you're engaging in an unlawful behavior and illegal action, of course, you have a duty to retreat. But if you're not engaged in any illegal action, and for most situations, there's no duty to retreat. And the stand your ground can happen in order to prevent that death or great bodily harm in any place.
So basically, like if I was walking my dog and then someone just came at me with a gun or a knife of some sort trying to cause great bodily harm, I could stand my ground and fight back.
Yeah, if you're in a place that you're legally allowed to be, you can stand your ground, you can meet force with force. There's no duty to retreat, and you're allowed to use the same force that is coming at you, basically.
Ooh, okay. Can you give me like an example or certain cases or that ties in with stand your ground?
Yeah, so there's one case right now that people have been talking about, and my friends, my legal friends, have been talking about, just as far as a case that's out there. I will start by saying I'm not personally involved in this case. Okay. Right, so
no NOA, nothing.
Not a prosecutor, not the defense attorney. The prosecutors haven't talked to me about the case. The defense attorneys haven't talked to me about the case. But the good thing for us about criminal cases is most of the information about a criminal case is public record. So I can just go on the court system and look cases up, and we're able to look up the documents that are filed in the criminal case because it's public record. So I'm able to just kind of look at a case that I find interesting and pull the records from the clerk and take a look at those documents. So there's one case that I pulled up, which is State versus Algeo. Allgeo. I'm probably not pronouncing it correctly. But I think it's a really interesting stand your ground situation.
What makes it stand out?
Well, the facts I think are pretty unique and they're complicated. So I'm really not going to get into the specifics of what happened, but it's basically a road rage incident.
Okay.
And I think what's interesting is the filing and the way that the filings happened, right? So in this case, there was originally an information filed for aggravated battery with a deadly weapon. But then a little less than a month later, there was a grand jury, and from the grand jury came an indictment for second-degree murder. And I think it's interesting, too, with just the kind of the ideas between an information and an indictment.
I was literally about to ask you, what's the difference between information and indictment?
So in Florida, the prosecutors can charge people with crimes in two ways.
Okay.
They can file an information stating that they believe that they have probable cause and they have all of the information necessary to prove this charge. And so they file the information, the formal information against the person, and that's a charging document. But in Florida, another way that prosecutors can file charges against individuals is through a grand jury. And I think that's a really interesting process because what happens there is they get a group of grand jurors together. They show the grand jurors all of the information, all of the facts about the case, and then that group of grand jurors really make the decision at that point what charges should be filed in the case.
Okay.
So in this situation, it's interesting because at first an information was filed. So a prosecutor looked at all of the evidence and said, you know what, I think it's appropriate for charges of an aggravated battery with a deadly weapon, which, you know, is a second-degree felony. It's still a big deal, but not that bad. But then later on, they went to a grand jury. And after the grand jury looked at all of the information and looked at all of the facts of the case, they decided, no, actually, the charge that should be filed is second-degree murder, which is much more serious. So that's the charge now that the defendant is facing is the second-degree murder charge because a grand jury issued an indictment for that charge.
That's wild. Now, how important is it, and let this be a call to action, but like how important is it to consult with an attorney if you're in a situation where self-defense is claimed or you're thinking you're within the rights of stand your ground?
Absolutely, incredibly important. I mean, obviously, in this case, a motion to dismiss based on stand your ground has been filed. A hearing is scheduled later on next month for the judge to decide whether or not the person should be immune from prosecution and whether stand your ground exists. So I think it is very important if somebody is ever charged with this type of crime or any type of crime that there may be a self-defense element to it, to talk to an attorney, because we can look at the statute and the law, and if we do believe that the facts are appropriate for immunity, for stand your ground, file the motion and get it in front of the judge for that decision to be made.
Beautiful information, great information. And with that being said, any final thoughts as we're wrapping this one up?
Nope. I'm excited to see. I'm going to keep watching the case, and I'm excited to see how it goes.
All right. Thank you so much for listening, and we'll see you guys next week. Thank you so much for listening. If you found this episode helpful or informative, don't forget to follow us on social media and share this podcast with your friends. Like, follow, subscribe so you never miss a show, and help others know their rights by spreading the word. Your support helps us keep fighting back. The information provided in the Fight It Back podcast is for general informational purposes only and is not intended as legal advice. Every case is unique and should be reviewed by a qualified attorney who can provide guidance based on the specific facts and circumstances of your case. Listening to this podcast does not create an attorney-client relationship with Fight It Law or any of its attorneys. If you are facing any legal issue, we strongly encourage you to consult with a licensed attorney directly.